The Bay Area Bar Association's annual awards gala was held at an oceanfront luxury hotel in San Francisco. Crystal chandeliers rained light across the grand ballroom. Champagne towers glittered under the warm glow, and the long lenses of media cameras were aimed at every corner. The audience was packed with tech company general counsels, industry heavyweights, and nearly every partner from my firm. I sat in the second-to-last row, at a table near the service exit, where the lighting was dimmer and the servers kept brushing past my chair. I was crumpling a napkin in my hand, twisting it into a tight knot, my fingernails digging so hard into my palm that I could feel the half-moon imprints forming like tiny scars. On stage, the man holding the trophy for Best Class Action Litigation Gold Award was Barrett Thorne. He was the managing partner of our firm, impeccably dressed in a bespoke charcoal suit that probably cost more than my monthly rent. His smile was camera-ready, practiced over years of media appearances, as he addressed the room with theatrical humility. "This honor belongs to the entire team," he said smoothly, lifting the trophy slightly toward the lights. "I've always believed that young lawyers shouldn't obsess over personal credit. Paving the way for senior colleagues is the path to long-term success. The firm is a collective, and we rise or fall together." Thunderous applause rolled through the ballroom. I heard people behind me whispering about how generous and classy he was, what a true leader he had become. A few junior associates near the front were nodding earnestly, taking mental notes, as if Barrett's words were gospel. They had no idea what that trophy really cost. 5 months of my life. 5 months of driving alone through the North Bay's winding coastal roads. 5 months of knocking on doors in senior housing complexes where the air smelled like mothballs and desperation. The case had been a nightmare. A financial investment company had systematically defrauded hundreds of elderly people out of their life savings. These were people who had worked their entire lives, who had raised children and paid mortgages and believed in the American dream, only to have everything stolen by smooth-talking brokers in cheap suits. For 5 months, I drove from town to town, sitting in cramped living rooms, holding wrinkled hands while people cried, recording their testimonies, gathering bank statements and fake investment contracts. I organized hundreds of thousands of pages of documents. I built the evidence chain from scratch. I drafted every single pretrial motion and settlement proposal. I worked until my eyes burned and my back seized up from hunching over a laptop in coffee shops and motel lobbies. I missed my mother's birthday and my best friend's wedding. I lived on gas station coffee and fast food that I barely tasted. Every night I came home and fell into bed fully clothed, too exhausted to even take off my shoes. And what did Barrett do? On the final day of the trial, he showed up at the courthouse 10 minutes before the hearing, wearing his best suit and his most confident smile. He stood there for all of 10 minutes, said a few practiced words to the judge, and walked out with a victory stamped with his name. All the credit went to him. His name on the award. His face on the podium. His relationships forged with tech giants who wanted to congratulate the firm's brilliant lead attorney. My name appeared exactly once, buried in an internal email that maybe 3 people ever read. A speck of dust that left no shadow. After the ceremony, he wandered over to my table with a champagne flute, his smile dripping with condescension. "Sarah, don't be so petty. It's just a case title. The firm is a collective, and we all contribute in our own ways. You'll have your turn someday." I kept my head down and said nothing. My nails were cutting into my palms so hard I felt a sting of warmth. But I didn't look up. I couldn't. Because if I had looked up, I would have said something I couldn't take back. And then, in that exact second, a pale blue light flickered before my eyes. It was like nothing I had ever seen. A translucent screen, floating in the air about 2 feet in front of my face, shimmering with a faint digital glow. It was clearer than any hallucination I'd ever heard described, more solid than a dream. Words scrolled across it in sharp white text. Failure prediction system binding complete. Host, Sarah Carter. A hyper-risk case will be assigned within 72 hours. Baseline loss rate, 97%. Case tags, Silicon Valley tech company exploiting gig workers. Platform tampering with work hour data. Key witnesses already bought. Accepting this case means permanent loss of partnership nomination. I blinked repeatedly, certain it was stress-induced delirium. I'd been working too hard, sleeping too little, and Barrett's smug face was probably the final trigger. But the panel stayed, cold and silent, suspended in the air as if it were the most natural thing in the world. What surprised me more than the vision itself was my own reaction. I expected panic. I expected confusion. Instead, I felt an absolute, crystalline calm settle over my chest. It was like someone had reached inside me and flipped a switch. The fear was still there, somewhere in the background, but it had been pushed aside by something much stronger. Something that felt a lot like anger, but cleaner. Sharper. I lifted my head and looked straight into Barrett's eyes. My voice came out level, steady, and completely unrecognizable to my own ears. "I'll take that case, Mr. Thorne. And everything you took from me? I'm going to get it all back. Piece by piece." Barrett's smile froze on his face. His hand, still holding the champagne flute, stopped mid-motion. His mouth opened slightly, like a fish that had just been pulled out of water. He clearly had never expected me to say anything like that in public, least of all at an event surrounded by industry peers and media. For years, I had been the quiet one, the reliable one, the one who nodded and said yes. He had no script for this version of me. A few lawyers at neighboring tables pretended to focus intently on their food. But their ears were clearly tuned in, their forks hovering motionless above their plates. The silence stretched for what felt like an eternity. Then Barrett laughed, a short, brittle sound that didn't reach his eyes. "Sarah, you've been working too hard. Go home and get some rest. You'll feel more like yourself tomorrow." He walked away, but I saw his grip tighten on the champagne flute. The knuckles were white. He was rattled, even if he wouldn't admit it. After the gala ended, my intern Mia scurried after me through the hotel lobby, her heels clicking frantically against the marble floor. She was barely 21, fresh out of college, with wide eyes and a nervous energy that reminded me of myself a decade ago. She had been with the firm for only 6 months, and I was her mentor. I could see the fear in her face, the way she was already calculating the professional consequences of what I'd just done. "Sarah, what were you thinking?" she hissed, her voice trembling. "He controls all the case assignments. He can destroy your career with one phone call. Everyone knows he's vindictive. The associates who crossed him before, where are they now? They're not at this firm anymore. They're not practicing law anywhere in the Bay Area." I stepped out onto the terrace overlooking the bay. The night air was cool and salt-tinged. The city lights glittered across the water like scattered diamonds, beautiful and indifferent. I leaned against the railing and took a long gulp of ice-cold sparkling water, the bubbles stinging my throat raw. "Don't worry, Mia. What he owes, he'll pay back eventually. I'm not the same person I was 6 months ago." She looked at me like I'd grown a second head. "What changed?" I didn't have an answer that would make sense to her. I couldn't explain the blue panel still hovering at the edge of my vision, patiently waiting. So I just said, I stopped being afraid of the wrong things. My phone buzzed. Barrett's text was right on schedule. Come to my office at 8 tomorrow morning to pick up your new case file. I typed back 2 words, received. The system's red 97% flashed again, glaring painfully in the dim terrace light. But that night, when I finally got home and collapsed into bed, I slept more soundly than I had in 6 months. Something inside me that had been wound tight for years finally snapped. And it felt like freedom. 8 o'clock sharp the next morning, I pushed open the door to Barrett's office. I knew that room intimately. 6 years of standing in front of that massive mahogany desk while he doled out assignments like a king tossing coins to peasants. 6 years of nodding and saying, "Yes, Mr. Thorne," like a broken record. 6 years of watching other people take credit for my work while I smiled and pretended it didn't hurt. The worn spot on the carpet in front of his desk was a monument to all the hours I'd spent there, being patient, being agreeable, being invisible. The wall behind his chair was covered with industry awards and partnership plaques, arranged in a careful hierarchy that placed his most recent trophies at eye level. Right in the center, positioned like a taunting, mocking eye, sat the gold trophy for the retirement home fraud case. The one he had stolen from me just a week ago. It gleamed under the track lighting as if it had always belonged there, as if I had never existed. Barrett leaned back in his leather chair, legs crossed, a thin smile playing at the corners of his mouth. He slid a stack of files across the desk toward me with theatrical gravity, like a general bestowing a battlefield command. "Sarah, you're the only one in this firm who can handle the media pressure from a tech giant of this magnitude. StarCloud Technologies' gig worker collective action case is yours. Consider it a vote of confidence in your abilities." I opened the file. Within 5 minutes, cold sweat was trickling down my spine. StarCloud Technologies was one of the largest outsourcing platforms in the Bay Area. Thousands of drivers, delivery workers, cleaners, and warehouse staff were all classified as independent contractors. No social security. No overtime pay. No sick leave. No job security. The platform could deactivate accounts at will, without explanation, leaving people destitute overnight. These were people with families, with rent to pay, with medical bills to cover. And StarCloud treated them like disposable parts. The back-end system was designed to automatically adjust work hour records, systematically wiping all overtime data from the logs. The original server logs had been purged months ago. No digital trail remained. It was a clean, professional job, the kind of data destruction that took planning and resources. Someone high up had signed off on this. Worse still, 3 internal clerks responsible for recording and verifying work hours had been paid off by the company. They had accepted hush money and had signed non-disclosure agreements. At trial, they would deny every overtime claim on the stand, smiling politely at the plaintiffs while betraying everything they knew. They would look the workers in the eyes and lie. And the most brutal irony of all was that StarCloud paid our firm millions of dollars in annual legal retainers. Every senior attorney in the firm had passed on this case when it was first circulated. No one wanted to upset a paying client. No one wanted to be associated with a guaranteed loss. So the case had bounced from desk to desk, gathering dust and silence, until it landed in the lap of the associate with the least political capital. Mine. The system updated with a full risk breakdown, scrolling in crisp white text. Current loss rate, 97%. Core risk, original server logs deleted. No direct electronic evidence. Secondary risk, 3 internal clerks will collusively recant their statements at the 24th minute of trial. Hidden clue, the administrative server room contains monthly manual paper backups of work hour ledgers. They are locked in a secure storage closet. I closed the file and locked eyes with Barrett. So everyone in this firm is too afraid to offend a major client, and you're dumping this guaranteed loss on me. As a career coffin nail. Barrett's expression flickered. He wasn't used to being challenged directly, especially not by someone who had always said yes. I could see him recalculating, trying to figure out what leverage he had lost and how to get it back. Sarah, you've been overly emotional lately. I understand the stress is getting to you. But you need to trust the division of labor. We all have roles to play. I understand division of labor perfectly. I picked up the file and stood, scraping my chair back against the carpet. The sound was harsh in the silent room. You take the good cases, grab the awards, and polish your reputation for the partnership. I clean up the messes that no one else will touch. If this case loses, which you've already decided it will, I'd appreciate it if you included the phrase teamwork in the firm's internal reprimand. That way, at least everyone will know what kind of division of labor we're really practicing here. The office went completely silent. Barrett stared at me, his lips pressed into a thin, bloodless line. For the first time in 6 years, I saw something like unease flicker behind his eyes. He was calculating, trying to figure out what had changed, what leverage he had lost. He had no idea that the answer was a floating blue screen that only I could see. I didn't wait for his answer. I turned and walked out, the file clutched against my chest like a shield. Over the next few days, Mia and I drove across the Bay Area, visiting the cramped apartments where Starcloud's exploited workers lived. The buildings were old, paint peeling, elevators broken, stairwells smelling of stale cooking oil and mildew. The workers slept in tiny rooms barely big enough for a bed, sometimes 3 or 4 people sharing a single unit to split the rent. Their children did homework on the floor because there was no table. Their phones were crammed with threatening messages from the platform's PR team. Take the few $1,000s in settlement and this ends. Keep fighting and we'll permanently deactivate your accounts. You'll never work on any platform in the Bay Area again. Is that what you want for your children? The lead worker was a man named Antonio, in his early 40s, with deep creases around his eyes from years of long shifts and sleepless nights. His hands were rough and calloused from loading boxes and driving through traffic. He clutched a stack of ride receipts in his lap, his knuckles white. His wife sat beside him, holding his arm, her eyes red from crying. "Lawyer, we don't want to sue anymore," he said, his voice thick with exhaustion. "They said they'll deactivate all our accounts. My wife, my brother, my cousin, we all work for them. If they ban us, our whole family starves. We can't fight anymore. We're too tired. I haven't slept through the night in months. Every time my phone rings, I think it's them telling me I'm finished." I sat down on the worn-out couch across from him, the springs digging into my thighs. The fabric was threadbare and smelled of cigarette smoke. "I understand. I really do. But listen to me carefully." I laid out the weaknesses one by one, speaking slowly so everyone in the room could follow. All you have right now are scattered screenshot records. The platform can tamper with data anytime, and without third-party verification, the court can't confirm over time. They'll argue that the screenshots could have been altered. They'll hire experts to say exactly that. And more critically, the 3 internal clerks who manage the work-hour records have been bought off. They will deny everything on the stand. They'll smile at you and say you never worked those hours. They'll be very convincing. Antonio's head snapped up. "How do you know?" someone inside flipped. I couldn't explain the system. I couldn't say, "I have a strange blue panel that tells me things." So I just said, "I've seen these tech company playbooks too many times. This is how they operate. They always have a few insiders on the payroll. Always. It's cheaper than paying overtime. The room fell quiet. The workers exchanged glances, fear and doubt flickering between them. They had been beaten down so many times that they had stopped believing victory was possible. Then an older worker in the corner stood up slowly. His name was Ernesto, and he had been delivering for StarCloud for more than 8 years. He was stooped, with a limp and a raspy voice from years of breathing exhaust fumes. He reached into the pocket of his faded jacket and pulled out a stack of yellowed paper slips, bound together with a rubber band. They were physical sign-in tickets he had collected each month from the offline partner stores where he picked up packages. "These are old," he said, his voice gravelly. "I kept them because I don't trust computers. Computers break. Paper stays. My father taught me that. He was a farmer, and he kept records on paper for 40 years. He said machines lie, but paper remembers." The system panel flickered instantly, new key documentary evidence acquired. Loss rate dropped to 83%. I took the slips from Ernesto's hand carefully, as if they were made of glass. "These are exactly what we need. This is proof. Actual, physical, tamper-proof proof. These tickets have dates, times, store stamps. They can't be deleted. They can't be altered." I turned to address the entire group. "Starting now, I want everyone to keep everything. Every payment receipt. Every ride screenshot. Every clock-in slip. Every chat log with dispatch. Every bank statement showing your deposits. Even a receipt from a year ago. Don't throw anything away. No matter how small it seems, it might be the piece that saves this case. If you have old calendars with your shifts marked, keep those too. Everything." For the next 4 days, Mia and I barely slept. We staked out the StarCloud administrative entrance before dawn, shivering in the cold morning air, waiting for employees to arrive. We finally cornered a former operations engineer who had been fired 6 months earlier. He was bitter about the way he'd been treated, and after an hour of talking over coffee in a diner, he agreed to hand over the original paper ledgers he had secretly copied before leaving. He pulled a thick binder from his bag and slid it across the table. "I kept these because I knew they'd try something like this. They fired me for not going along with their schemes." We ran to a dozen offline partner stores scattered across the Bay Area, from corner convenience stores to industrial warehouses to gas stations. We pulled surveillance footage from the past 2 years, sometimes spending hours convincing store managers to let us review their hard drives. We filed formal motions with the court to obtain records from the California Labor Commissioner's office, uncovering prior citations against StarCloud going back 5 years. There was a pattern, a history of violations that the company had managed to bury. Every single piece of peripheral evidence was notarized, certified, and secured in a locked file cabinet that I moved into my apartment for safekeeping. I didn't trust the office after what Barrett had done. But the 3 clerks remained untraceable. Their phones were disconnected. Their apartments had been vacated. Their social media accounts had gone dark. They had vanished as if they had never existed. I hired a private investigator with what little savings I had, but even he couldn't find them. It was as if StarCloud had made them disappear. On the day before trial, a storm warning was issued for the Bay Area. The sky turned a strange greenish-gray, and the rain started falling in sheets. Mia called me at 6 in the evening, breathless with excitement. "Sarah, I found something. They're working weekend shifts at a chain gym on the outskirts of town. All 3 of them. Tonight is their shift. They're there right now. My cousin saw one of them there last week and recognized her. I grabbed my coat and drove through the downpour, windshield wipers struggling against the deluge. When I reached the gym's parking lot, the rain was so heavy I could barely see the building through the water cascading down my windows. I sat in my car for a few minutes, watching the entrance, my heart pounding. I stood under my umbrella at the gym's back entrance and waited. At 11:30, the three clerks walked out together, laughing about something. They saw me and their faces went pale. The first reaction was to run. They turned and started hurrying toward the side street. "Don't run!" I shouted, my voice cutting through the pounding rain. "StarCloud threatened your families. They threatened your children's school placements. They told you they'd ruin you if you talked. I know everything. I have notarized copies of every threatening text message between you and your supervisors. And I have California witness protection application forms ready to file right now." They stopped. They stood frozen under the dim streetlight, rain plastering their hair to their faces, their eyes wide with terror. I stepped closer. "I know you're scared. You're terrified, and you have every right to be. But think about what you're doing. You're helping a $10 billion company crush hundreds of working-class families. All for a few $1,000s in hush money that will be gone in a month. In California, perjury is a criminal offense. You could go to prison. Your families could lose you forever." The three of them looked at each other for a long, heavy moment. The rain kept falling, a steady curtain of water that seemed to isolate us from the rest of the world. Then one of them, a woman named Lisa, crumpled to the wet ground. She hugged her knees and sobbed, the sound swallowed by the storm. "I have 2 kids," she choked out. "They told me they'd take my kids away if I didn't cooperate. They showed me pictures of my daughter's school. They said they knew her schedule. I didn't know what else to do. I was so scared." The other 2 broke down behind her. One of them, a young man, dropped to his knees. "My mother is in a nursing home," he said. "They told me they'd make sure she lost her bed if I talked. She's all I have left." I knelt down, regardless of the water soaking through my suit pants, and put a hand on Lisa's shoulder. "No one is going to take your children. I promise you that. No one is going to hurt your mother. If you testify truthfully, if you tell the court what really happened, I will personally make sure you and your families are protected. I have the paperwork. The legal system can protect you if you let it. But you have to trust me." They looked at each other again. Then Lisa wiped her face and nodded. The young man nodded too. The third clerk, a woman who hadn't spoken, finally said, "Okay. We'll tell the truth." The next morning, they agreed to testify truthfully. The system refreshed, witness recantation risk neutralized. Loss rate reduced to 58%. I stood in the hallway outside Barrett's office, feeling something that might have been hope. At the pretrial settlement conference, I met the opposing counsel for the first time. Jared Hale. He dressed simply and cleanly, no flashy ties or expensive accessories. His sleeves were rolled to his forearms, revealing a plain watch. He carried a leather briefcase that was scuffed at the corners, worn from years of use. Every piece of his evidence was organized chronologically with razor-sharp precision, each tab labeled in neat handwriting. He argued with surgical precision, attacking points, not people. His voice was calm and measured, never raised. He didn't mock, didn't sneer, didn't posture. He simply laid out the facts as he saw them and let their weight do the work. StarCloud had paid top dollar for him, and it was easy to see why. He was the kind of lawyer who won cases not through theatrics but through sheer competence. His opening statement cut straight to our weakness. The plaintiffs have no complete original electronic work hour logs. The scattered paper slips they've submitted are of dubious authenticity. They cannot prove a consistent pattern of long-term overtime. The existing evidence is insufficient to support the wage claims. Without those logs, they have no case. I fired back without hesitation. The defendant intentionally deleted original server work hour data, which constitutes obstruction of justice. The paper sign-in slips, store surveillance footage, testimonies from former operations engineers, and labor commissioner records form a complete evidentiary chain. The defense can't claim the evidence is insufficient when they destroyed the evidence themselves. Mediation collapsed within 45 minutes. Neither side was willing to bend, and the mediator looked exhausted. In the hallway outside the conference room, Jared called out to me. "Sarah, I'm not trying to be difficult. But the evidence and public sentiment in this case heavily favor my client. If you push this to trial, you're going to damage your professional reputation. The media will frame this as a frivolous lawsuit against a tech company that creates jobs for thousands of people. You'll be painted as the lawyer who went after the little guy's livelihood." I stopped and turned to face him. "Are you preemptively declaring defeat for your opponent, Mr. Hale? That's unusually generous of you." His expression remained unchanged. "It's not generosity. It's an objective observation. Your clients are emotional, and you're letting that emotion drive your strategy. That's a mistake. Emotion gets you nowhere in a courtroom. Thanks for the advice." I met his eyes. "Let me return the favor. Don't let StarCloud's generous retainer blind you to the facts. They destroyed the evidence. They blackmailed their own employees. They've been systematically abusing these workers for years. If you're so confident in your case, why did they need to wipe the server logs? Why did they need to threaten witnesses? Innocent people don't do that." Jared was quiet for a moment. Then he said, "That's a fair point. But it's still not enough to win. Intent isn't proof. At trial, it will be." Mia hovered behind me, clutching her file folder nervously. "Sarah, is he going to be a problem? He seems so calm and confident. What if he finds a hole in our evidence?" I handed her a cup of hot coffee from the vending machine. "Don't worry. There are no truly kind opponents in this profession. But there are honest ones. I think he's honest. And in the courtroom, the only thing that matters is the evidence. He'll fight us hard, but he'll fight fair." Jared was silent for 2 seconds, then nodded slightly at me. "See you in court. See you in court." The courtroom was packed on the day of trial. Tech journalists filled the front rows, their laptops already open. Attorneys from other platform companies sat in the middle sections, taking careful notes. StarCloud's own PR team occupied the back row, clipboards at the ready, recording every word, every gesture, every expression. They were there to spin whatever happened. Judge Morrison was a veteran, gray-haired and sharp-eyed, someone who had seen every trick in the book. He maintained a calm, neutral expression through the opening statements, letting both sides lay out their cases. At the 24th minute of proceedings, the 3 clerks took the stand. All eyes were on them. Everyone in the courtroom expected them to recant their statements, just as StarCloud had instructed. The PR team in the back row was already smiling, pencils poised. But Lisa, the first to speak, started crying almost immediately. Her voice was unsteady, but every word was clear. "StarCloud told us to lie," she said. "They sat us down in a conference room and said if we denied the overtime claims, we'd each get $20,000. If we told the truth, they'd fire us and make sure we never worked in this industry again. They showed us photos of our children's schools. They said they'd make our lives hell. They said they knew where we lived. The courtroom erupted in murmurs. Judge Morrison banged his gavel sharply. Silence in the court. Continue. The three clerks testified one after another, detailing how the platform had altered work-hour logs, how they had been bribed and threatened to keep silent, and how they had been told to lie under oath. Original copies of the threatening text messages were submitted into evidence. Jared rose immediately, his cross-examination fierce and relentless. He attacked the validity of the paper slips, the continuity of the evidence, the motivations of the witnesses. His questions came like machine gun fire, trying to find a crack in the testimony. He was brilliant, and every question was designed to make the witnesses doubt themselves. But I had prepared them. I answered every single question with evidence. I laid out the labor commissioner records, the former engineer's full testimony, the surveillance footage from a dozen stores, the original paper ledgers from the server room, and the digital forensics report. Each piece of evidence was a brick, and I was building a wall so solid that no amount of cross-examination could breach it. Brick by brick, I made it impossible for Jared to find a way through. Finally, I submitted the court-approved search warrant for StarCloud's administrative storage closet. Inside, the paper backup ledgers had been hidden behind a false panel. They proved, beyond any doubt, that the company had deliberately destroyed electronic work-hour records to hide their illegal practices. The system flashed, evidence chain complete. Loss rate reduced to 24%. Judge Morrison banged the gavel again and ordered StarCloud to produce a formal settlement proposal immediately. The corporate executives in the back row looked like they had been slapped. Their PR team's confident smiles had vanished. A week later, the verdict came down. StarCloud was ordered to pay all back overtime wages, retroactive Social Security contributions, and punitive damages for emotional distress. The total was in the millions. The labor commissioner simultaneously initiated substantial administrative penalties. On the day of victory, Barrett had the audacity to call me at 9 in the morning. "Congratulations, Sarah. There's an industry media interview tonight. I'll attend with you. We'll present the case as a collaborative firm effort." Collaborative? I laughed. You provided zero support, zero resources, and zero morale. But sure. Let's do the interview together. I'd love to have you there. Live on air, the host asked, who was the lead attorney on this groundbreaking case? Barrett opened his mouth to take the credit. But I had anticipated this. I connected my laptop to the studio's projector and displayed our firm's internal email on the giant screen behind us. Sender, Barrett Thorne. Date, the day I had taken the file. Message, the StarCloud labor case carries enormous PR risk. The firm will allocate no resources to this matter. Sarah Carter will handle it independently with no performance-based compensation. If the case is lost, the firm will take no responsibility. The studio went dead silent. The host's face froze in shock. The camera zoomed in on Barrett, his complexion shifting through shades of white and purple. For a full 10 seconds, nobody spoke. I leaned toward the microphone and said, calmly, Mr. Thorne was indeed deeply involved in this case. His primary contribution was determining in advance that we would lose, then providing me with zero support and zero resources for the entire duration. The case was won entirely through my independent efforts. The workers were represented by me, and only me. After the interview, in the underground parking garage, Barrett blocked my path. His face was livid. "Sarah Carter, Do you really think winning one case is enough to shake my position at this firm? You're a junior associate. I've been a partner for 15 years. I know everyone who matters. You're nothing. You'll always be nothing. I opened my car door and glanced back at him. I don't know if I can stay standing in this firm. But I'm sure of one thing. You're not going to sleep tonight. And you're not going to forget this for a very long time. Because deep down, you know I'm right. And that scares you more than anything. I drove off, leaving him standing alone in the dim garage. Barrett's retaliation came faster and more comprehensively than I had anticipated. All high-value tech commercial cases were immediately redirected away from me. Department meetings stopped including my name on the invite list. High-end client briefings had my presence crossed off at the last minute. Cross-team projects systematically wrote me out of every assignment. My performance bonuses were halved month by month until nothing remained but base salary. Mia carried files to my desk, her shoulders slumped and her eyes downcast. Sarah, we're being completely frozen out. They're not even pretending anymore. Everyone at the water cooler stops talking when I walk past. It's like I'm invisible. I stirred my coffee slowly, watching the dark liquid swirl. I told you. It's not a freeze. It's cryogenic preservation. They're waiting for me to quit voluntarily so they don't have to pay severance. It's cheaper that way. What are you going to do? Work harder. That's all we can do. And wait for the right moment. A few days later, the admin dropped off a new file. Another case no one wanted. A coastal real estate developer had been burying construction waste near a residential community for years. The groundwater was contaminated, and hundreds of residents were suffering from chronic skin conditions and respiratory illnesses. The developer had deep political connections and had already made it clear that any law firm that took the case would lose all future business from the entire real estate industry. The system warned, current loss rate, 76%. Hidden risk, developer forged water quality reports and bribed the third-party testing lab. Mia flipped through the materials and sighed. Long evidence gathering cycle, low fees, and the developer has powerful connections. I don't know how we win this one. The previous firms that looked at it all said the same thing. They couldn't compete with the developer's resources. I looked out the window toward the distant coastal community. I could see elderly residents dragging large water jugs down the street to buy purified drinking water. The image was burned into my memory. The developer thinks a settlement check can make everything go away. I'm going to show the court that hundreds of people's health and lives can't be settled with a few checks. If we win, we're not just winning a case. We're telling every developer in the state that they can't buy their way out of poisoning people. I stayed in the coastal community for nearly 2 weeks, moving between a cheap motel and residents' homes. I knocked on every door in the affected area, introducing myself and explaining my purpose. I collected over 100 medical records, water sample logs, and annual physical reports. I interviewed families who had lost loved ones to illnesses that doctors couldn't explain. I sat in their living rooms and listened to their stories, their anger, their grief. Eventually, I tracked down a former third-party tester who had been fired by the developer 8 years ago. He had kept the original test results, which showed contamination levels several hundred times above legal limits. They told me to falsify the report, he said. I refused, so they fired me. I've been carrying this for 8 years. I wanted to expose them, but nobody would listen. They said I was crazy. Now someone is listening, I said. Will you testify? He looked at the file in his hands, then back at me. Yes, I've waited long enough. I want my name cleared. At trial, Barrett personally appeared to defend the developer. He spent the entire proceeding sneering at me, trying to undermine my credibility. Sarah Carter has built her entire reputation by exploiting vulnerable groups for media attention. She doesn't care about these people. She cares about headlines. She's a publicity hound. I didn't react. I simply laid out each piece of evidence, one by one. A geographic distribution map of the illnesses, color-coded by severity. Water sample test logs showing clear contamination patterns. The developer's internal construction waste disposal records, which had been obtained through a court order. Internal emails proving the developer knew about the contamination years ago and did nothing. The original water quality reports from the fired tester. Medical expert testimony from 3 independent physicians. Every one of Barrett's defenses crumbled like paper in a storm. He had no answer for the evidence, and everyone in the room could see it. After the hearing, an elderly resident clutching her husband's medical file approached me with tears in her eyes. "Did we win today? Is it over?" I shook my head gently. The verdict isn't in yet. But the developer is starting to panic. I could see it in their lawyer's face. They know they've been caught. Whatever happens, they can't hide anymore. And that's a victory in itself. 2 months later, we won at the first instance. The developer was ordered to cover full medical compensation for all affected residents, permanently shut down the landfill, and fund a comprehensive groundwater remediation plan for the entire community. The judgment was published in several local newspapers, and other communities began to take notice. After that case, my name spread through the Bay Area's community advocacy circles. I started receiving calls from people I didn't know, grateful residents from other communities who had heard about the case and wanted to know if I could help them too. Jared sent me a message: "Your evidence handling on this case was thorough and well organized. You presented a compelling case." I typed a one-word reply: "Thanks." Mia rolled her eyes. "Can you be slightly warmer to your peers?" He's being nice. Adults don't need small talk. Professional courtesy is enough. After the coastal case win, Barrett grew more threatened by me than ever. He called an emergency department meeting and issued a direct edict. I was prohibited from taking any low-fee community advocacy cases. I would only handle high-value corporate commercial matters. If I didn't comply, I would be transferred out of litigation entirely. In front of the entire department, he said something I would remember for the rest of my career. "Cheap moral righteousness doesn't pay the bills. A lawyer's job is to accommodate the capital interests of our clients. We're not a charity. We're a business. And businesses exist to make money." I stood up from the conference table, the scrape of my chair loud against the carpet. All eyes turned to me. Justice doesn't have a price tag. The grievances of ordinary people deserve the same serious legal response as the grievances of corporations. If this firm has forgotten that, then it's no longer a place I want to be. That afternoon, I typed my resignation letter on my laptop. It was brief and direct. I hereby resign from the firm, effective immediately. My final cases have been closed and transitioned. Thank you for the opportunities one was given. I printed it out on the office printer, placed it flat on Barrett's desk, and walked out without looking back. I left the firm where I had spent 6 years of my life. 6 years of long hours, sleepless nights, stolen credit, and unfulfilled promises. I walked through the lobby one last time, past the associates who had watched me struggle and said nothing, and stepped out into the sunlight. I rented a tiny office in a rundown building in Oakland, far from the glittering towers of San Francisco. It had no floor-to-ceiling windows, no reception desk, no dedicated administrative staff. There was one old printer that jammed constantly, 2 second-hand desks I bought from a closing office supply store, and a swivel chair that squeaked with every movement. The building's elevator was perpetually out of order, and the hallway lighting flickered. Mia followed me without a second thought. "I don't care about the money," she said. "I just want to work somewhere I can actually be proud of what we do. Somewhere I can sleep at night." I taped a single sheet of A4 paper to the door, printed in a font I'd chosen at random. It said, simply, Carter Litigation. Within weeks, several large corporate firms approached me with lucrative partnership offers. They named their price, threw in signing bonuses, promised prestigious corner offices and dedicated support staff. The only condition was the same across every offer: give up all community advocacy and pro bono cases, work exclusively for corporate clients. I turned every single one down. "Are you crazy?" one recruiter said, baffled. "This is a 7-figure package. You could be set for life in 5 years." "I could also hate myself in 5 years," I said. "Pass. I'd rather sleep well than sleep rich." Then a case arrived that I couldn't refuse. A 16-year-old girl named Claire had suffered years of emotional and physical abuse from her legal guardian. Her father had died when she was young, and her mother had remarried a man who saw Claire as a burden. The stepfather beat her, locked her in her room for days at a time, and left her with no food. The mother either looked the other way or pretended it wasn't happening. On the night everything changed, Claire fought back. She defended herself against the stepfather, who was drunk and attacking her, and injured him with a kitchen knife. The stepfather survived, but he pressed charges. The media painted Claire as a violent, rebellious delinquent. The police initially classified the incident as assault. She sat in my office on that broken chair, so thin that she looked like a gust of wind would knock her over. Her sleeves were covered in old and new bruises, some purple, some yellowed with age. She barely spoke at first. Finally, she asked just one question. "Do you believe me? Everyone else says I'm lying. They say I'm crazy." The system flashed: current loss rate, 86%. Long-term abuse evidence largely missing. Public opinion polarized. Taking this case will permanently terminate all corporate firm partnerships. I looked at the lucrative partnership offers still sitting in my email inbox. I opened the drawer, dropped them in, and locked it. Then I pulled out the intake forms and said to her, "I believe you. I'll help you. You don't have to go back to that house. I promise you that." Claire cried for the first time in my office, silent tears rolling down her cheeks. She didn't make a sound. Just tears, endless tears, as if she had been holding them in for years. The hardest part of this case was the wall of silence surrounding it. The stepfather's relatives all provided false alibis, claiming he was a kind and gentle man who never raised his voice. The neighbors pretended not to hear anything, even though later testimony revealed they had heard screaming on multiple occasions. The school had never reported any signs of abuse, even though teachers had noticed the bruises. Everyone had seen something, and no one had acted. I visited Claire in juvenile detention more than a dozen times, sitting in that sterile visiting room with the scratched plastic table and the humming fluorescent lights. We talked for hours. I asked her to tell me everything, and I peeled back her story like layers of an onion. She had asked her mother to protect her and been told she was being dramatic. She had cried to a school counselor and been told family matters should stay within the family. She had called a child welfare hotline once, and the operator had told her to try resolving it through family discussion. Every door had slammed in her face. Every person she had trusted had failed her. The day I walked out of the detention center, Jared was standing in the hallway. The public defender's office had assigned him as Claire's criminal defense counsel. We split the work without even discussing it. He reviewed the criminal procedure, injury assessment, and interrogation records for any procedural flaws. He built the legal defense that Claire's actions were justified self-defense. I handled the long-term abuse evidence chain, gathering records from 3 years of school nurse visits, classroom journal entries, and neighbor testimony. The most crucial piece came from a former neighbor who had finally agreed to speak. "I heard the screaming almost every night," she said. "But I was afraid to get involved. The stepfather was always so charming during the day. I told myself it wasn't my business. I was wrong. I'm ready to tell the truth now. I've been carrying this guilt for too long." She also revealed something I hadn't expected. The Guardian had consistently played loud music through the house speakers every night to cover Claire's crying. The stepfather would turn on the stereo at maximum volume, and the entire neighborhood would hear classic rock blasting at odd hours. Everyone thought it was strange, but no one ever questioned it. The system updated, long-term abuse evidence chain established. Loss rate reduced to 45%. Before trial, Claire's mother came to my office. She was a thin, anxious woman with nervous hands and darting eyes. She started crying almost immediately. "Please," she begged. "Please convince Claire to admit she was wrong. We can settle this outside of court. We can make it all go away. I just want my daughter back." I laid the entire evidence file out on the table in front of her. Medical records. Photos of the bruises. Witness statements. School reports. "You heard her being hit," I said quietly. "You heard her begging for help. You did nothing. Every time she reached out, you turned away. And now you want her to apologize?" The mother opened her mouth. Nothing came out. She looked at the photos, and for the first time, she seemed to actually see them. "I didn't know it was that bad," she whispered. "Yes, you did," I said. "You just didn't want to look. But now you have to." On the day of trial, the rain poured down. The gallery was packed with media from outlets across the state. The courtroom was so crowded that people were standing along the walls. The opposing counsel grilled Claire relentlessly. "Why didn't you call the police? Why didn't you run away? Why did you wait so long to ask for help?" Jared rose and presented the full evidence of long-term abuse. He reconstructed a teenage girl's years of helplessness, her desperate pleas for help that had been ignored at every step. He read her journal entries out loud, her private words capturing a loneliness and pain that no child should ever have to experience. Finally, the mother was called to the stand. She collapsed under questioning, admitting that she had known about the abuse all along. On the night of the incident, she had heard Claire screaming for help. She had done nothing. She had pretended to be asleep. "I was scared too," she whispered. "I was scared of him. I was scared of being alone. I made the wrong choice." The system updated, loss rate reduced to 19%. The court ruled that Claire's actions constituted self-defense, considering the long-term abuse and her status as a minor. Her sentence was significantly reduced. The judge ordered a change of guardianship, appointing a court-approved guardian to take Claire in. She would not have to return to that household ever again. When it was over, Claire hugged me outside the courthouse. She was light as a bird finally finding a branch to rest on, her arms so thin they barely reached around my shoulders. "Thank you," she whispered. Thank you for believing me. I told her, if anything ever comes up, call me anytime. Day or night. I'll answer. After Claire's case, I thought I could finally catch my breath. I sat in that tiny Oakland office, afternoon sunlight falling across the worn wooden floor. The old printer that was perpetually jamming sat in the corner, a silent testament to our humble resources. Mia was asleep on her desk, her face pressed into a stack of papers. She had been pulling all-nighters for 3 straight days, organizing files and cross-referencing documents. I poured myself a cup of instant coffee, leaned back in that squeaky chair, and let my mind wander. The past 6 months had been a marathon. Case after case, barely any breathing room between. But I had won every single one. The office was humble, but we were still standing. We were still fighting. Mia stirred, lifting her head with keyboard marks pressed into her cheek. Her eyes were puffy from exhaustion. Sarah, can we take one day off? Just one. I want to sleep for 24 hours straight. Let's finish organizing the workers' comp file first. Then we'll talk. You said that last month, she mumbled, but she was already reaching for her notebook again. I laughed. Just as I was about to say something else, the landline on my desk rang. That was the office number listed publicly, the one that brought in random inquiries, wrong numbers, and occasionally real clients. I picked it up. Is this Attorney Carter? A woman's voice, mid-40s, tense and strained. Yes. How can I help? She paused for several seconds, and I could hear her breathing heavily on the other end. She was gathering courage. My name is Irene Foster. I'm the former finance director of the Bay Area Children's Welfare Foundation. I want to report my former boss, Executive Director Robert Sterling. He's been embezzling funds, forging donation records, and sexually harassing subordinates. At least 3 female employees have been subjected to long-term harassment. I have some financial evidence, but I'm afraid to come forward alone. My hand froze midair. The coffee cup wobbled against the edge of the desk, a few drops spilling onto my papers. The Bay Area Children's Welfare Foundation was one of San Francisco's most prominent nonprofits. Tens of millions raised annually. Major tech companies competed to donate and have their names on the charity's donor wall. Sterling himself had just been named a Bay Area Philanthropic Leader of the Year last month, and his photo had appeared on the front page of the business section. He was the darling of the city. The system slowly faded into view. New case alert. Case type: nonprofit embezzlement/sexual harassment/witness intimidation. Current loss rate: undetermined. Minimum information available. Preliminary risk assessment: opposing party controls extensive social resources, media relationships, and political business networks. Whistleblower faces immediate personal safety threats. I kept my voice steady. Irene, is your current residence safe? Are you living alone? I'm staying with a friend in another city. I'm too afraid to go back to my own apartment. I think they've been watching the building. I've seen cars I don't recognize parked outside. Listen to me carefully. I made my tone as calm as I could. Don't touch any of the related materials. Split the copies of your evidence and store them in separate locations. I'll arrange to meet with you as soon as possible. If anything feels off, call the police immediately. Do not handle it alone. Do not confront anyone. Just get to safety and call me. I hung up. Mia was fully alert now, her exhaustion replaced by adrenaline, her eyes wide. What case? A big one. Bigger than StarCloud. Bigger than the developer. I grabbed my jacket from the back of the chair. Let's go buy a new burner phone. Now. 3 days later, Mia and I met Irene at a nondescript coffee shop on the outskirts of Oakland. It was in a strip mall with a laundromat and a dollar store, the kind of place where nobody looked twice at anyone. Irene was in her mid-40s, with graying brown hair pulled back in a loose ponytail, wearing a plain wool cardigan that had seen better days. Her eyes were full of weariness and exhaustion, dark circles underneath testifying to sleepless nights. She sat in the corner booth, her coffee untouched and growing cold, her fingers wrapped around the cup as if for warmth. I slid the burner phone across the table. Use this from now on. No calls to your old contacts on your old phone. What did you do with your old phone? Tossed it in the bay, she said, her voice barely audible. I was afraid of being tracked. I know how paranoid that sounds, but I couldn't shake the feeling. It doesn't sound paranoid. It sounds like a survival instinct. I signaled Mia to start the recorder. Start from the beginning. Don't leave anything out. Even if it seems small. Irene was silent for a long moment. Then the words came out in fragments, like pieces of a puzzle that had been hidden away for years. She had joined the foundation as finance director 5 years ago. Everything had seemed normal at first. The foundation was professional, well-run, well-funded. But in her second year, she began noticing irregularities. Large donations would come in, and after a delay, the funds would be routed out under labels like consulting fees and project outsourcing to shell companies. Each transfer was modest, $30,000 to $80,000, but over the course of a year, it added up to over $1 million. When she tried to investigate, she found that her financial system access had been quietly restricted. The records she had been able to view were no longer available to her. I was told it was a system upgrade, she said. But I didn't believe it. I knew something was wrong. I just couldn't prove it. Then she noticed how Sterling treated female employees. At least 3 young women had been called into his office for private meetings, and emerged with red eyes and misaligned buttons. One left the organization too terrified to say a word. Another tried to file an internal complaint and was fired for unsatisfactory performance within 2 weeks. The termination file written in generic corporate language that meant nothing and said everything. Irene began secretly copying whatever financial documents she could still access. She used a personal flash drive and worked late at night when the building was empty. Then she discovered that her login records had been audited. Someone had been reviewing her search history, her access patterns. She resigned the next day. But after she left, the intimidation began. Her mail was rifled through. Her car was keyed repeatedly. Silent calls came in the middle of the night, sometimes 3 or 4 times a week. I don't have direct proof that the intimidation came from him, she said, her fingers trembling. But I know it did. He never does anything himself. That's his style. But he makes sure everyone knows he can get to you. He has people everywhere. I asked, what about the board of directors? Anyone there who might be willing to help? Irene laughed bitterly. 12 directors. 5 are his business cronies from the corporate world. 2 are his college friends. The rest are either bought off with consulting fees or completely checked out. They don't care what happens as long as the money keeps coming and the annual reports look good. I rubbed my temples. This was more complicated than StarCloud. More complicated than the developer. This was a system designed to protect a predator. After Irene left, the system displayed, decision confirmed. High-risk public corruption case initiated. Current information insufficient. Loss rate estimated at 92%. Key evidence required: complete internal financial records. Formal testimonies from sexual harassment victims. Shell company registration and fund flow documentation. Direct link between Sterling and Shell companies. Mia and I spent 2 weeks pulling every thread we could find. We went to the California Secretary of State's office and pulled the Shell company registration records. Every single one listed the same office address, a generic suite in a downtown building. Every corporate officer was a name that led nowhere, probably fictitious or borrowed identities. But there was one thread we followed. The registered phone number for one of the Shell companies was only 2 digits different from Sterling's executive assistant's direct line. Not enough to convict, but enough to raise serious questions. The harder part was finding people. Irene had given us several names, former employees she remembered as being harassed. We spent days tracking them down. The first had moved to Los Angeles. She hung up as soon as I mentioned the foundation. The second opened her door and started crying. "I have children to raise. I can't afford to lose my job. I can't afford to be associated with this. Please don't come back." The third and fourth either refused to talk or flatly denied everything. Mia was visibly struggling during that period. She spent her days interviewing with me, trying to convince frightened people to speak, and her nights organizing documents. Often the lights were still on at 2 or 3 in the morning. One night I came back to the office to retrieve a file and found her asleep face down on her keyboard. The screen still showed a bank transaction tracking page for one of the Shell companies. A thin line of drool had formed on the edge of the desk. I draped my jacket over her shoulders. She mumbled, half asleep, "Sarah, why are all these people so afraid? Why won't they just tell the truth?" and then drifted off again. I stood in that dark little office, looking out at Oakland's murky streetlights reflecting off the wet pavement, and realized this case was even heavier than I had anticipated. We were fighting not just Sterling but a whole culture of fear that had been cultivated for years. The breakthrough came 2 weeks later. I got an anonymous call at the office, the burner phone number. A young woman's voice, thick with tears and fear. "Is this Attorney Carter? My name is Megan. I'm the current administrative assistant at the foundation. Sterling told me to come to his office tomorrow. I know what he wants to do. I'm scared. Can you help me?" My grip tightened on the phone. "Where are you now? Are you safe?" "I'm in my car in the building parking lot. I can't go back up. I saw him walk past my desk an hour ago." He smiled at me and said, "Don't forget our meeting tomorrow." I know what that smile means. I've seen it before, what happened to other girls who got that smile. "Stay on the line. I'm coming to get you. Lock the doors. Don't open for anyone. Not security, not a coworker, not anyone." I drove through the rain, faster than I should have, the windshield wipers beating a frantic rhythm. When I pulled up to the foundation building, I spotted a beat-up Toyota with a small figure hunched in the driver's seat. I tapped on the window. She flinched, then slowly cracked it open an inch. "Megan? I'm Sarah Carter." She stared at me for a long moment, her eyes red from crying, her mascara smudged. Then she threw the door open and collapsed into my arms, shaking violently, unable to speak. The rain was pouring. I held my umbrella over both of us and patted her back gently. "It's okay. You're safe now. I'm here." We sat in my car for almost an hour while she composed herself. She told me that Sterling had been grooming her for months, making suggestive comments, inviting her to private dinners, and finally scheduling this evaluation that she knew was a setup. "He does this to every young woman who works there," she said. "I've seen the pattern. They all leave, and none of them say anything publicly. He's been doing this for years." The next day, I took Megan to buy the smallest, most discreet voice recorder I could find. Then I installed a background recording app on her phone as a backup. When Sterling calls you into his office, keep your phone face down on the desk. Let the app run. Don't press anything. If he crosses the line, repeat his words back as naturally as you can, and let him say it again. We need 2 full statements to build a credible case. 1 statement is a he said she said. 2 statements start to look like a pattern. Megan's face was pale, but she bit her lip and nodded. "I'll try. I'll do it for the other women. For the ones who were too afraid." At 3 in the afternoon, I sat in the coffee shop across from the Foundation building, nursing a latte that had long gone cold, watching Megan's location on my phone. Mia was shaking her leg beside me, tapping her fingers on the table. At 3:40, Megan's location moved from the admin floor to the executive level. 47 agonizing minutes passed. At 4:27, my phone vibrated. Megan's text, "I'm out. Going to the parking lot now. I'll head to the safe house address you gave me." 40 minutes later, I met her at the safe house, a small apartment I had rented specifically for witness protection. She was pale but stable, her hands still trembling slightly. She handed me her phone. I got it. I kept my voice as steady as I could. I plugged in the recording and put on my headphones. Sterling's voice came through clearly, starting with a standard quarterly review, then shifting gradually into something darker. "Megan, I've always admired you. Young, attractive, ambitious. At this foundation, you have tremendous potential. But you should know that potential always requires a mentor. Someone who can guide you, open doors for you. I'm offering to be that mentor." Megan's voice was barely audible. "I don't understand what you mean, Mr. Sterling." Sterling's tone changed, slick and predatory. "You understand perfectly. Every successful woman has had a man who guided her. Someone who believed in her. I'm not asking for anything in return. Just a gesture of appreciation. A sign that you know how to be grateful. Tonight. 8 o'clock. Room 8806 at the Bay Hotel. We'll have dinner. We'll talk about your future." A long silence. Then Megan, "I need to think about it." "Take your time." Sterling laughed, a low, self-satisfied sound. "But opportunity doesn't wait forever. I hope you'll make the right choice." I pulled the headphones off and looked at Megan. The tears were finally falling, but she was biting her lip, refusing to let out the sobs. "Megan, you're not going to that hotel tonight. Tomorrow, send your resignation email. Say it's for personal reasons. I have a new SIM card ready for you. Move into the safe house for as long as you need. I'll cover all expenses. Your safety is the priority." She looked at me through her tears. "Will he actually be punished? Everyone says he's untouchable. Everyone says he has too many connections. Is it even possible?" I held her cold hand firmly. "It will be hard. It will take time. There will be more battles before it's over. But I promise you, he will pay. Maybe not tomorrow, maybe not next week, but he will pay." The system updated, key witness testimony acquired. Direct sexual harassment recording obtained. Loss rate estimate reduced to 74%. Next critical step, acquire core foundation financial data. By the time I got Megan settled into the safe house, it was past midnight. I lay in bed staring at the ceiling, running every thread through my mind again. The next morning, something I never expected happened. Davis, a senior partner from my former firm, Barrett's firm, was standing outside my office door when I arrived. He wore a perfectly tailored suit and an expression that was trying very hard to look friendly. "Sarah, it's been too long. You look well." I let him in, and he looked around the tiny office with barely concealed disdain. He took in the old printer, the creaky chair, the handwritten iron rule on the wall. His expression remained neutral, but I could see him calculating. "Let me be direct," he said, sitting down without being invited. After Barrett's license was revoked, the firm lost a lot of major clients. Several of our most valuable accounts have indicated they might consider returning if you rejoined as a partner. The board also feels that your recent reputation in community advocacy would benefit our brand image. I didn't even touch the document he slid across the desk. "What's the catch, Davis?" "There's always a catch with you people." His smile tightened slightly. "The catch is that you stop your current investigation into the Children's Foundation. The Foundation's lead director, Robert Sterling, is a long-standing personal client of several of our senior partners. Your continued pursuit of this matter would cause significant commercial friction. We can't have that." I was quiet for a few seconds. Then I laughed. "So you came all the way to Oakland, to this tiny office with the squeaky chairs and the broken printer, to ask me to drop a sex harassment and embezzlement case against a non-profit director, just to protect a client relationship?" Davis's expression hardened. "Sarah, you're being unrealistic." "I'm being realistic." I stood up. "After Barrett lost his license, your firm has become desperate. You'll represent anyone for a fee now. You've lost your moral compass, and you want me to lose mine too?" The answer is no. Davis was silent for a moment. Then his tone turned cold. "Sarah, I hope you understand the situation clearly. Sterling has more influence in this city than you can imagine. You're running a small operation here. The consequences of going up against him could be severe for you and for anyone associated with you. I'm not threatening you. I'm warning you, as someone who remembers the hardworking associate you used to be. Thanks for the warning." I opened the office door. "The exit is that way. I won't see you out." He stopped at the doorway and looked back. "You've changed. You never used to be so confrontational. So defiant?" I corrected. "For 6 years, I let people walk all over me. Now I'm standing on ground I own. Why would I ever go back?" After the door closed, Mia peeked out from her cubicle, her face pale. "Sarah, you just turned down a partnership offer." "That was probably 7 figures. 7 figures buys my spine," I said, sitting back down heavily. "It's too expensive. I'm not selling." That night, as I was organizing financial documents, the burner phone assigned to Megan rang. Her voice was shaking. "Sarah, my Twitter account was hacked. Someone posted really disgusting things using my name. Really vile stuff. All my friends and family are asking me what's going on. My mom called me crying. She thinks I've lost my mind. Retaliation. Pure, calculated retaliation. Megan, don't panic. Change your password immediately. Screenshot everything. Do not delete anything. Do not respond to any media inquiries, no matter how tempting. Tomorrow morning, we're filing a police report for cyber harassment and identity theft." Within 48 hours, the digital assault was in full swing. A long, Detailed thread appeared in the Bay Area legal section of Reddit, titled, "The Truth About Sarah Carter, Influence Peddler or Actual Lawyer?" It rehashed the StarCloud and Coastal developer cases, insinuating I had exploited vulnerable groups for media attention, and that my evidence chain relied entirely on media hype rather than factual proof. The comment section was flooded with freshly created accounts, all repeating the same talking points. Then a professionally written blog post began circulating in legal circles, accusing me of exaggerating a minor's victimhood to manipulate public opinion and interfere with judicial fairness. Mia was furious. "Can't we sue them? This is defamation. They're destroying our reputation." I shook my head slowly. Every claim is phrased with weasel words. Questionable. Worth examining. Deserves further review. There's no direct defamatory statement. This is a professional PR job. They've done this before. So we just take it? No. I opened my Twitter account and started posting. I attached the complete verdict from StarCloud, the judge's full opinion, and the Labor Commissioner's penalty order. Then I posted the court's findings from Claire's case, bolding the line that said, "Self-defense claim sustained," and "Long-term abuse factually established." I added, "I'm Sarah Carter. Every case I've handled stands up to legal and public scrutiny. If you disagree with my methods, feel free to challenge them in court." 3 days later, I received a formal notice from the California State Bar's Ethics Committee. Someone had filed a complaint against me in Claire's case, alleging improper use of media to influence judicial proceedings. I had 10 days to respond. I sat with that letter for a long time. "Instead of getting upset, let's focus on the facts," I told Mia. "Print out every interview I gave on Claire's case. Every podcast appearance. Every print article. Every radio segment. We're going to go through every single word." That night, we covered half the office with printed transcripts and worked for over 2 hours. The conclusion was clear: every public statement I had made was strictly limited to information already in the public domain. I compiled a formal response and submitted it that night. Under the dual pressure, I accelerated the foundation case. Irene's peripheral records formed an outline, but we were missing the direct connection between the foundation's accounts and Sterling's personal accounts. The foundation published flawless annual reports, but those reports are meant for the public, Irene said. The real system doesn't match. But the core server is accessible only to Sterling. That door was closed. But I noticed another detail: the foundation's financial outsourcing was handled by Harbor Financial Consulting. Its registered agent was Richard Morrison. Mia and I spent 3 days digging. We found an old resume he had posted years earlier. One line read, 2018 to present, Bay Area Children's Welfare Foundation, Financial Outsourcing Management. It included a contact number. I called. A middle-aged man's voice picked up. "Mr. Morrison? My name is Sarah Carter. I need to ask you something. In the financial system your company handles, have you noticed unusual transfers to shell consulting companies?" The breathing on the other end halted. "I don't know what you're talking about. Don't call again." But I heard the faintest intake of breath, the reaction of someone confronted with a truth they'd been hiding. I drafted a formal attorney letter requesting records. On the 5th day, I got a response. Morrison's voice was low and weary. "I want to meet you. Neutral place." We met at a roadside diner. He pulled out a brown envelope. "This contains the complete records. Every external consulting contract, project service fee, they're fake. Sterling used my firm as a conduit. He bought an $800,000 yacht with foundation money. Why are you giving this to me? Last year, my daughter was diagnosed with leukemia. I asked Sterling for an advance. He said, the company has procedures. 3 weeks later, he bought that yacht. To him, people like me weren't even worth a spare part. I took the envelope. The system updated, core financial evidence acquired. Loss rate reduced to 43%. The next morning, I filed an emergency petition to freeze the foundation's accounts and Sterling's assets. It was granted. I forwarded the evidence to the California Department of Justice and the IRS. The story broke the next morning. Sterling called that night. Attorney Carter. You've made a serious mistake. The question you should be asking is what happens when donors find out their money bought your yacht. I'll give you one final chance. Withdraw the case. Continue this path, and I will make your life a living hell. I suggest you find a good criminal defense attorney. I included your full name and your yacht's registration number in my IRS submission. He hung up. I convened the 3 women at the safe house. Sterling's assets are frozen. But he'll do everything to stop you from testifying. Megan, he can't buy me off. Kayla, I'm done being silent. Nicole, I'm afraid for my parents. I've applied for temporary witness protection for all of you. 3 days before trial, Sterling resigned. 3 major donors suspended funding. The IRS initiated a criminal investigation. The night before trial, the system updated, overall loss rate, 24%. On the day of trial, the courtroom was packed. Megan took the stand. She recounted the evaluation, and the recording was played. The courtroom went dead silent. Sterling's attorney attacked the legality of the recording. I was ready. California law permits one-party consent. Nicole followed, playing her brief recording. Then Kayla. The afternoon session moved to financial evidence. I submitted Morrison's records and walked the court through the money trail. I isolated the yacht transfer. This occurred in March of last year. In the same period, the Foundation's annual report showed a 12% decline in children's program spending. Judge Morrison looked at Sterling. Do you acknowledge that these funds entered your personal accounts? Sterling chose to remain silent. The trial lasted 3 days. On the 4th day, the judge ruled, sexual harassment claims sustained. Financial fraud sustained. Sterling was barred from serving as a California nonprofit director for 10 years. 4 weeks later, a federal grand jury indicted Sterling on wire fraud, tax fraud, and money laundering. He appeared on the news in an orange jumpsuit. 3 weeks after the case, I received an invitation from my former firm to speak at their industry salon. I went. At the podium, I said, 6 years ago, I was told to accommodate capital interests. I thought if I worked hard enough, I'd be recognized. I was wrong. The more I accommodated, the more I was taken advantage of. It's not accommodation that earns respect. It's standing up and saying, this is mine, and you can't take it. I left. Today, my fees may be lower. My office may be small. But every dollar is clean, and every client knows I'll never abandon them. After the Foundation case, Carter litigation hit a turning point. New clients started finding us. Mia began handling smaller cases independently. One afternoon, after winning a labor dispute, she burst into the office and jumped twice in excitement. Mia, if you want to laugh, laugh. She grinned. You should have seen the landlord's face. One warm July evening, we sat on the office windowsill. Mia walked in with bubble tea. To celebrate our first month in the black. I took the cup. This time last year, we had $800. She asked, "Have you ever wondered what your life would look like if we hadn't left?" I thought about it. Probably still at that firm. Still having my cases stolen. Passing Barrett in the hallway, him smiling, saying, "Sarah, don't be so petty." We burst out laughing. She said quietly, "You've really changed. You used to tolerate everything. Now you seem fearless." It's not that I'm not afraid. But being afraid doesn't solve anything. The more you tolerate, the more people think you deserve to be treated that way. And now? Now anyone who tries to step on me had better have good balance. Another Monday morning. I found a new file on the reception desk, Antonio Garcia et al., 37 dockworkers, versus Pacific Freight Company, workers' compensation dispute. Same pattern. Large company withholding compensation. Workers had lost 3 rounds of arbitration. The pale blue panel displayed, "New case alert. Current loss rate, 93%. 93%. The same number as StarCloud." Mia smiled. 93%. Just like old times. Do you think we can win? I tucked the file under my arm. We can win. As long as the evidence is complete, the facts are clear, and the law is on our side. The day the dockworkers case was won, Antonio showed up with a bag of oranges. I'm not a rich man. These are from my cousin's farm. I accepted the bag. At the door, he turned back. "You know, lawyer, you look different. Back then, there was something in your eyes. Like you were always worrying. Now you seem lighter." I leaned against the doorframe. I used to worry about losing everything. Now I just focus on winning the next thing. I went back to my desk and placed the oranges next to the small succulent Claire had given me, the hand-woven scarf from the coastal community, and the signed thank you card from the StarCloud workers. Each told a different story. The system panel floated quietly in the corner of my vision. I didn't need to watch the numbers anymore. They had become background noise. Because I knew, whether the next case came with 97% or 24%, I would take it and fight it through to the end. Outside, the San Francisco Bay skyline stretched into the setting sun. In thousands of buildings, ordinary people lived their ordinary lives. And my job, when they faced injustice they couldn't fight alone, was to stand on their side. Nothing more. Nothing less. That was enough. That was everything.